you in court. And it also seems that any potential reasonability argument that Mr. Ross was in fear of his life evaporates the second he's to the side of the car. And additionally, use of force experts analyzing the video footage of the incident have also questioned Mr. Ross's decision to shoot at a moving vehicle at all. Most police departments, including Hennepin counties, discourage shooting at a moving vehicle because deadly force is unlikely to stop a car and could endanger bystanders. Now, it's also not 100% clear that an ICE agent qualifies as a peace officer for purposes of Minnesota's use of deadly force statute. And if so, then Mr. Ross could attempt to defend against a murder charge on the basis of self-defense under Minnesota law. But under this scenario, the state would bear the burden of proving beyond a reasonable doubt that Mr. Ross was not acting in self-defense at the time he shot Miss Good. But under these circumstances, Mr. Ross would find it difficult, if not impossible, to prevail on a self-defense claim given that Minnesota's self-defense law applies only where the accused was not the aggressor and imposes a duty to retreat. To defeat a claim of self-defense, the state must disprove beyond a reasonable doubt that at least one of the four elements of self-defense, the absence of aggression or provocation in the part of the officer, to the officer's actual and honest belief that he was in imminent danger or death or great bodily harm, and that the action taken was necessary to avert that danger, the existence of reasonable grounds for that belief, and the absence of reasonable possibility of retreat to avoid the danger. And I think a jury would be hard-pressed to find that Mr. Ross did not engage in the aggression or provocation that ultimately resulted in the shooting. Video footage shows Mr. Ross approaching Miss Good's SUV, encircling it on the right side as he takes video with his phone, and re-emerging near the driver's front side of the car. And he first draws his gun as the SUV reverses away from him. And while the aggressor in an incident generally has no right to claim self-defense under Minnesota law, an original aggressor can still claim self-defense if he actually and in good faith withdrew from the conflict and communicated that withdrawal expressly or impliedly to his intended victim. But here, the video footage shows no withdrawal or communication of withdrawal. To the contrary, it shows Mr. Ross originally instigating the incident and then proceeding with the escalation of tactics, nearing the vehicle, drawing his weapon, and aiming it at Miss Good. And another hurdle facing Mr. Ross in a self-defense analysis is his failure to retreat. A valid self-defense claim requires the, quote, absence of a reasonable possibility of retreat to avoid the danger. And the Minnesota Supreme Court has explained that a reasonable opportunity to retreat exists if there are, quote, options for escape or avoidance of peril rather than directly confronting someone. And here the video footage shows that Mr. Ross had time to get out of the way of the SUV because he did. Mr. Ross was not trapped. He was not unfettered in his ability to escape, back away, or otherwise protect himself. And in fact, he had the opportunity to take out his gun and shoot the driver. If I was the prosecutor, I would certainly argue that a reasonable officer would have done everything that they can to get out of the way first before even thinking of unholstering their firearm. And of course, maybe put the video camera down too. Mr. Ross did neither and still was seemingly unscathed. This failure to retreat or safely avoid the confrontation before resorting to force likely dooms any claim of self-defense in a non-peace officer scenario. On top of that, the state could argue that Mr. Ross did not have a reasonable basis to believe that he was in imminent danger of death and that the discharge of his firearm was necessary to avert that danger. That's because an objective standard applies to the amount of force used. In other words, the force must be proportionate to the threat and limited to that which would appear to be necessary to a reasonable person under the circumstances. Lastly, it's come to light that Mr. Ross is a 10-year veteran of ICE and was involved in the prior months in a similar situation that did result in his injury. And although Mr. Ross would likely argue that his past experience of being dragged by a car in a previous ICE enforcement operation demonstrates his actual and honest belief that he was in imminent danger of death or great bodily harm, the state might use that same evidence to show that he was still traumatized by that incident and his belief was unreasonable. Now, as if the shooting itself couldn't have gotten any worse, towards the end of the video footage, we see other federal agents impeding a physician's attempt to render aid or to check the pulse of Miss Good as she lay slumped over the steering wheel of her car. Witnesses also report that ICE vehicles blocked an ambulance that arrived on the scene. These obstructions of medical aid could prove further grounds for liability against the agents under Minnesota law. Minnesota Statute Section 609.662 imposes a duty to render aid to shooting victims. Specifically, the statute provides the, quote, a person who discharges a firearm and knows or has reason to know that the discharge has caused bodily harm to another person shall, 1, immediately investigate the extent of the person's injuries, and 2, render immediate reasonable assistance to the injured person. If the victim suffers death or great bodily harm as a result of the discharge, the person who discharged the firearm is subject to imprisonment of up to 2 years and or fines up to $4,000. Here, although Mr. Ross does appear to take his time in checking on Miss Good's condition and instructing his colleagues to call 911, his response might be deemed inadequate given that he's whisked away just seconds later. But it's also possible that response does meet the statutory obligations. Now, to the extent that ICE agents might have deterred bystanders and ambulances from reaching Miss Good to administer aid, those agents may also be liable under Minnesota Statute 609.50, which prohibits the obstruction of legal process. That law subjects liability to anyone who, among other things, intentionally interferes with or obstructs a member of an ambulance personnel crew who is providing or attempting to provide emergency care. And the reports are that it took a significant amount of time for the ambulances to appear. ICE agents did not allow ambulances to park next to the victim, and as a result, they were forced to walk a significant distance to render aid. And the penalty for any such violation where the accused knew or had reason to know his obstruction created a risk of or actual death or substantial bodily harm is subject to imprisonment of up to 5 years and fines of up to $10,000. And less significantly, Minnesota's Good Samaritan law imposes a general duty to assist a person at the scene of an emergency who is exposed to or has suffered grave physical harm, but the violation of this law results only in misdemeanor liability. And finally, criminal liability may also be available for the other ICE agents involved in the obstruction of medical care if it's found that these officers' actions or failures to act resulted in a death that could have been prevented by earlier medical treatment under Minnesota Statute 609.205. With all this said, it remains unclear whether the state will in fact press charges. Minnesota Attorney General Keith Ellison has stated that anyone who broke the law as part of this incident will be held accountable. And the Hennepin County's Attorney's Office has already stated it has jurisdiction to bring criminal charges against federal officers involved in the shooting. Although the Minnesota Bureau of Criminal Apprehension initially said it was partnering with the FBI to conduct a joint investigation into the shooting, it later announced that it has been notified by the FBI that the investigation would be led solely by the FBI, and that the Minnesota Bureau would no longer have access to case materials, scene evidence, or investigative interviews necessary to complete a thorough and independent investigation. The Bureau further stated it may not be able to present a case for prosecution without access to evidence gathered at the scene of the fatality, especially when it's in the possession of the